Good evening, everyone, and welcome to our Hague Mothers International webinar. It's fantastic to have all of you here from 28 countries across the globe for our first Hague Mothers International webinar. Hague Mothers is a Filia-supported project that aims to end the injustices which arise from the implementation of the Hague Convention. We'd like to give huge thanks to Filia for all its help and work in creating and supporting Hague Mothers, and particularly thanks to our wondrous coordinator, Ruth Deneen. Thank you too to Brunel University Global Lives for co-hosting this webinar. And we'd like to thank Sarah, who's working hard behind the scenes for her tech support. And of course, thanks to all the experts involved in the webinar and to their institutions. Our aim in this webinar is to raise awareness of the problems with the Hague Convention across the board, as well as in the specific jurisdictions that you'll hear about this morning, this afternoon, or this evening, depending on where you are. And how the process can be changed to protect and benefit children and victims of domestic violence and abuse. Now, we're aware that there are differences in terminology across the jurisdictions that are involved in this webinar. And we'll try to ensure that the terminology used is comprehensible generally, but it may not always be possible in specific presentations. So I'm now going to ask each of our panelists to introduce themselves. And if I'll start with myself to make it easier for everyone. So I'm Adrienne Barnett. I'm a reader in law at Brunel University, London. I have researched domestic abuse and family court proceedings for many years, and I also practiced as a family law barrister for many years, including in Hague Convention cases. And I'll be giving an overview of the main problems with the Hague Convention, and then I'll talk about some problems specific to England and Wales.
I'm Jeffrey Edelson. I'm a professor at the University of California, Berkeley, social scientist, and my involvement in the Hague Convention has been as a researcher on the topic of children's exposure to violence and how it represents a grave risk. And I'll be talking about some of that research in my talk. Thank you, Adrienne.
Hi there, I'm Miranda Kay. I am in Australia, where I'm based at UTS in Sydney. I'm originally from the UK, where I practiced as a family lawyer and also taught, and I now mainly teach and research family law, including Hague matters.
Hi, everyone. My name is Nicole Fiddler. I'm an attorney from the United States. I work at an organization called Sanctuary for Families. We are a New York-based nonprofit that provides comprehensive services to survivors of domestic violence, sex trafficking, and other forms of gender-based violence. I am director of the Pro Bono Project at Sanctuary, where I try to leverage law firm attorneys and resources to increase access to justice for survivors. I also work with survivors who have fled to the US with their children and find themselves facing a Hague Convention petition in the US. My piece of the presentation today will focus on some of the specific challenges that survivors face under the current Hague legal paradigm in the US. And I'll also talk briefly about one recent positive change in US case law.
Yes, hi, I'm Sudha Shetty, and I am from UC Berkeley, the Assistant Dean of International Partnerships and Alliances. My expertise, I'm a lawyer by practice, and I work with battered mothers, immigrant battered mothers through the US courts. And I've been currently working on the international aspects of the Hague Convention and the civil aspects of child abduction. And I will be focusing on sort of the conclusion and sort of what do we need to do next in order to really work to help women who are fleeing across international borders.
Thank you. I'm now going to tell you a bit about Ben Keith. Ben can't be with us this evening, but we will be playing a video of his presentation. So Ben Keith is a barrister at Woodward Street Chambers in Wellington, New Zealand, and has conducted proceedings at all levels. He's designated as a special advocate under the Immigration Act 2009 and was an active member of 2 New Zealand Law Society law reform committees. His presentation will consider the situation in New Zealand, and in particular, a recent case that he's worked on. Sonia, would you like to introduce yourself?
Yes, hello everyone, very nice to be here. My name is Dr. Sonia Ibe Carlson. I'm based at the UCL in the UK. I lead a research group called Everyday Disasters and Violences. I'm also part of another research group that's called Shira. And tonight I'll be taking your questions and try to answer some of them, as well as passing a few of them to the panel.
Thank you. And now, Kim, would you like to introduce yourself?
Hi, lovely to be here. Well, as you know, I'm Kim Fawcett, and I'm a teaching fellow in criminal law and criminal justice at Durham University in the UK. I also teach on the family law module as well. I became interested in The Hague because I am a Hague mum, and many years ago, that's how I ended up interested in The Hague. So I went on to do a law degree, and then I decided to write a PhD, and the focus of my PhD is the Hague Convention and the links to domestic abuse and coercive and controlling behaviour. I will also be answering your questions along with Sonia, so please feel free to ask what you would like.
Thank you very much. Thank you so much to our panelists for introducing themselves. And we're now going to start the presentations. So I will now be presenting on the, as I said, an overview of the Hague Convention. So I'm just going to share my screen. Oops. So what I'm going to be talking about, as I said, is an overview of the Hague Convention, pinpointing some of the key problems, and then I'll discuss some issues that are specific to England and Wales. So what is the 1980 Hague Convention? Its full title is the Convention on the Civil Aspects of International Child Abduction. It was signed on the 25th of October 1980, and now over 100 states have contracted into the Hague Convention. And what it does in general terms is it protects rights of custody and access although it's primarily used to protect rights of custody. A little about the background. What we're going to look at is what the drafters of the Hague Convention had in mind. So during the 1970s, when the Hague Convention was being formulated, it was intended to deal with non-resident parents primarily, principally fathers, who might abduct the child or children across international borders without the other parent's permission, for various reasons. And this is encapsulated by this statement by Mrs. Justice Hale, as she then was, who talked about the stereotypical picture of a child abduction as the non-custodial parent kidnapping the child from the custodial parent and then disappearing with the child. However, is that correct? What we know from ongoing research over the past 20 years is that around 75% of taking parents are in fact primary carer mothers, and many of them are fleeing domestic violence and abuse. So how does the Hague Convention work? It's called a remedy of hot pursuit, which really encapsulates what's called the prompt return principle. The idea being that it enables this, the speedy return to the state of habitual residence of children under 16 who have been wrongfully removed to or retained in another contracting state. So the whole idea is that proceedings are very quick, return orders should be effective very quickly to reverse the effects of an abduction. Return orders are, if the application is made within 12 months of the wrongful removal or retention, mandatory. Now that means that if the court is satisfied that the abducting parent has wrongfully removed or retained a child in breach of the other parent's rights of custody, the court must return the child forthwith. In other words, it has no discretion. There are some limited defenses available under the Hague Convention to the taking parent, but there is no defense of domestic violence or abuse. So mothers who may want to raise domestic violence or abuse have to rely on the grave risk of harm defense, which is available under Article 13b. Article 13b says that a court may not order the return of the child if the person opposing the return establishes that there's a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. That's what the taking parent would have to prove. So what are the problems? Firstly, the courts of most contracting states apply the grave risk defense very strictly. There is a high burden on the taking parent to prove this. It's very difficult to establish that domestic violence or abuse gives rise to a grave risk or intolerable situation. And in most contracting states, only in rare cases will domestic violence or abuse be seen as so severe as to amount to an Article 13b defense. Another issue is that courts may be too willing to accept what's called protective measures in order to justify return orders. So even if a grave risk is demonstrated, then courts may be willing to accept conditions on return orders or mirror orders or accept undertakings from the left behind parent. Such limited research as there is shows that these are often ineffective. They may be ignored or breached with no repercussions. There's also a lack of focus on the welfare of the individual child and on risk assessment. So whereas the welfare of the child is the guiding principle in the domestic law of many contracting states, the welfare of individual children is not the court's paramount consideration under the Hague Convention. Additionally, the summary nature of proceedings, in other words, proceedings take place very quickly, there's not usually oral evidence heard, means that risk is inadequately assessed, if it is assessed at all. Very often risk to the mother isn't even a factor, unless of course the court can be persuaded that it indirectly impacts on the child. There is a guide to good practice to Article 13b, which was issued in 2018 after about 7 years of drafting and trying to get it through all the member states. It was intended to introduce uniformity in the implementation of the Hague, of Article 13b, but there are a few issues with it. One being that it continues to emphasize the strict interpretation of Article 13b for domestic violence and abuse cases. And although it does recognize that there are problems with undertakings as protective measures, for example, that they may not be easily enforceable, it does continue to endorse so-called protective measures as justifying return orders. The other issue is that mothers and children who may be compelled to return can be left in dire circumstances. They could be exposed to further abuse. They could be subject to homelessness, destitution, isolation, and even possible criminal proceedings. And then there's the issue of inequality of arms. While legal aid may be automatically available in many contracting states for the left behind parent, this is not usually the case for taking parents, who may be subject to means and merits tests, or legal aid may not be available at all. So going on to issues that are specific to the implementation of the Hague Convention in England and Wales. The grave risk defense continues in many courts of first instance to be applied very strictly. The case law emphasizes that only in rare circumstances will domestic abuse be seen as so severe as to meet an Article 13b defense. However, despite some judgments from the Supreme Court and from our very own Lady Hale, who you can see in this picture, that the Article 13b should not be applied more strictly than the terminology of its wording, in many cases this continues to be the case. Now, the leading case on Article 13b in England and Wales is Re E, a 2011 judgment of the Supreme Court, and it implemented a three-stage approach. And bear in mind that the taking parent, the victim of domestic abuse, has to bear the burden of proving each stage of this three-stage approach. So the first stage is what's called identify the risks. In other words, would the risks being alleged, if found proved, amount to an Article 13b defense? If the answer to that is yes, the next question the court has to consider is, would protective measures alleviate the risk? If they would alleviate the risk, then that's the end of the matter, and the court is obliged to make a return order. If the answer is no, then the court has to do the best it can within summary proceedings to resolve the disputed issues. Now, the problem is cases often fall at the second hurdle. So even if a grave risk is established in principle, it is difficult in many cases to prove that protective measures wouldn't mitigate or alleviate the risk. Protective measures are widely construed, but in a number of cases, it's been emphasized that they must be effective. Another issue is the inconsistent application of Article 13b and of the 3E approach. While some courts do recognize domestic violence and abuse as giving rise to a grave risk or intolerable situation, equally many do not, even in cases with similar facts. However, to conclude, on the positive side, we have seen recently some very informative and positive judgments from the higher courts. Over the past 5 years, in a number of cases, the Court of Appeal has overturned decisions of the High Court on the basis, for example, that the 3E approach has not been followed, or the court has underestimated the risk of domestic violence or abuse. Now, this gives a strong indication that there's perhaps an inadequate application by the lower courts of Article 13b, but it demonstrates that Article 13b can and should be applied to recognize the harmful nature of domestic violence and abuse. And a very good example of this is this excellent decision by Lord Justice Moylan in the case of Re A. So I will leave you with this quote by Lord Justice Moylan and leave on a positive note as to where we can go in terms of Hague Convention proceedings. Thank you very much for listening to my presentation. I'm now going to hand you over to Jeffrey Edelson, who will talk to you from the perspective of the US.
Thank you, Adrian. And there are a lot of things that I will reinforce in my talk. So my talk is mostly going to be based on the work that I've done with my colleague, Taryn Lindhorst from the University of Washington. We published this book in 2012, and then an upcoming chapter in Marilyn Freeman and Nikki Taylor's new book that I wrote with Sudha Shetty and Mary Fata. I will happily send e-copies of both the book and the chapter upon request. So I want to first start by setting context for US Hague Convention cases. The social science research is very clear that child exposure to adult domestic violence may definitely cause psychological harm, and probably does in the majority of cases. And about half of the families where a mother is abused, we find that the child is also abused. And those studies vary over a wide number of different settings: child welfare, domestic violence, age shelters, and the like. And in the US, many judges do recognize domestic violence as a potential harm to children, the exposure to adult domestic violence as a harm to children in many domestic custody cases. But as I'll say in a minute, it's been slow to be recognized in Hague cases in the US. The US is also unique in some ways in that there's 17,000 different judges who can hear a Hague petition case. They can be state judges or federal court judges. And so that's a large number of judges. Most judges and the lawyers representing clients will only see a few Hague Convention cases in their entire careers. And the result of that is that there's a pretty low level of knowledge about the Hague Convention and grave risk, and experience with Hague cases. So while the domestic courts have been better at recognizing domestic violence as a risk to children, in Hague cases, judges have been pretty slow to recognize that. But there are some very good rulings by judges in state and federal courts, and I want to emphasize some of those. In Walsh, the judge reversed a return order because of the psychological abuse of the father's children and the physical abuse of the father by the mother. And in another case, Khan v. Fatima, the judge stated, well, this remedy of return is appropriate when it's a non-custodial parent, it's inappropriate when the abductor is a primary caregiver who's fleeing for the safety of herself and her children. And so there is beginning case law to establish that domestic violence does raise a risk and can be considered under 13(1)(b). In another case, Krishna, the judge rejected a Hague petition and found compelling evidence of the potential of serious psychological harm. And I think too often our judges focus on physical harm to the children and not the psychological harm, which it's both physical and psychological harm are both elements of a 13(b), Article 13(b) defense. And in Sardopoulos, the judge held that spousal abuse should be considered when deciding grave risk because of the potential that the abuser will also abuse the child. So again, recognizing this research that if a mother is being abused, it's highly likely that the child in the same household will also be physically abused or psychologically harmed. Now, Adrian mentioned before undertakings, and a related idea is a mirror order. As Adrian mentioned, the Hague's Permanent Bureau Guide to Good Practice on Article 13(b) encourages the use of undertakings and mirror orders. But what an undertaking is a voluntary, and I can't stress enough that it's a voluntary undertaking that the left behind parent in the other country agrees to certain conditions to ensure the protection of the child and the mother on their return to the country of habitual residence. A judge in the US or a judge anywhere in the world may reach out to the other country, a judge in the other country, and establish what's called a mirror order. So the other country's court enters the same order in their court as the judge has written in an undertaking in the US case. Now, the research on undertakings and mirror orders, despite the encouragement of the Hague Permanent Secretariat and a lot of other writers about the Hague Convention, authors, the only studies we have are very few. Marilyn Freeman's work with Reunite International in a study of UK cases found that 67, really 2/3 of the undertakings were not enforced on return to the other country, and that none of those in the cases she studied that were aimed at protecting the child were enforced on return of the child to the other country. In Taryn Lindhorst and my study of US cases, we found very similar findings. Undertakings are frequently violated on return of the child, and mirror orders are seldom enforced by the other country's courts. That's not surprising given the research, even on domestic restraining orders, orders for protection, and the like, that many perpetrators violate those orders, even in domestic cases, and very much so in these international child abduction cases. There is skepticism, growing skepticism among some US judges, and I want to stress some. It's not necessarily representative of all judges, but in the Van de Sande case, the judge ruled that the courts don't need to consider the home country's ability to protect the child. They need to decide whether that child will be safe on return and not whether that country can or cannot protect the child. In Khan, the judge ruled that undertakings and mirror orders were inadequate in protecting children based on our study in the US and Marilyn Freeman's study in the UK. And then finally in Walsh, the judge stated, and this is a great statement, we have no doubt that the Irish courts would issue appropriate protective orders. This is not the issue. The issue is the father's history of violating orders issued by any court. And I would emphasize that many of these fathers have a history of violating court orders, violating the law, perpetrating criminal violence against their partners and children. And so I think this judge in Walsh was very right to consider seriously the history of violating orders by the perpetrator, the left behind parent. And on a final note, and I think this should be a key takeaway from my talk, is the work of Professor Merle Weiner, who's probably one of the best scholars on the Hague Convention and domestic violence at the University of Oregon in the US, that she has argued in a recent article that exposure alone is sufficient to establish grave risk. Because the article states that there's a grave risk of his or her return would expose, not certainly have the child a victim, but simply expose the child to physical or psychological harm, or otherwise place the child in an intolerable situation. And I would argue that returning a child to a formerly abusive partner, a left behind parent in the other country, runs a very high risk of exposing that child to physical harm, and if not physical harm, certainly psychological harm on return to the other country. So with that, I'm going to conclude and turn it over to Adrian and the next presenter.
Thank you so much, Jeff, for that positive account of some recent judgments in the US, and also for enlightening us about the problems and effectiveness of so-called protective measures. I'm now delighted to introduce Miranda Kay, who will talk to you about some exciting developments in Australia.
I just first want to acknowledge the traditional custodians on the lands of which I present, the Gadigal people of the Eora Nation. I'd like to pay respect to elders past and present and any Aboriginal and Torres Strait Islander people on this webinar. I recognise the strength and resilience of Aboriginal and Torres Strait Islander people, especially those who've been affected by domestic and family violence, and recognise the additional damage caused by the legal system of which I'm a part. So in Australia, very unlike the position that Jeff has just presented, Hague matters tend to be heard by a very small handful of judges. So we don't have the same variation in practice and outcomes as there is in some other countries. Indeed, Australia has historically been very proud of its consistently high record of returns of children. In May last year, Australia elected a new Labor government, and the new Attorney General reiterated a promise that he made before election that he was committed to safeguarding victims of domestic violence who faced the Hague application. And soon after election, in December 2022, he announced a change to the regulation that implements the exceptions to return. And because those changes did not need to go through Parliament, they literally took effect overnight. So I just want to go through what those changes were and then talk a little bit more about them. So the changes take the form of a note, which is attached to Regulation 16, which is effectively Article 13B in the Australian regulations. And this is the first part of the note. It simply says, when the courts are considering grave risk, the court may have regard to any risk of exposure or to family violence. And it goes on to say the court may also have regard to the extent to which the child could be protected from any such risk if the child was returned under the convention. I think it's obvious that the wording should not be may. I don't know why the note, which is great in many ways, says that the judges may take account of family violence. In many cases, they had that option in any event. So I think the wording should simply be changed, and I hope that we can do this. I think the Attorney General may well be open to further changes to simply say that the court must have regard to any risk of family violence. Obviously, if there's no violence, they don't have to do so. The second or the last part of the note, and it's the last paragraph of the note, I think is very important. So the court can have regard to basically exposure to family violence, regardless of whether they're satisfied that the family violence has occurred, will occur, or is likely to occur. This is really important because of the huge difficulties that both the former speakers have talked about for women in proving violence from outside the country where the violence took place in summary proceedings. To date, a lack of corroborated evidence of domestic and family violence in many Australian cases has led to courts not even considering not returning the child. So, in conclusion, in relation to the note or the amendments, I think Australia was really brave in doing this. I think it was a great start, but further additions to the note, in addition to what I've already said, would be a huge improvement. I think the note should be clarified to explicitly say that if there's a grave risk, then a judge must consider non-return. I'm concerned that the current drafting continues to privilege return in the way that it's drafted. There should also be a new note that the presence of protective measures does not mean that women and children are safe. Jeff has illustrated this perfectly. We know this. We all know that legal systems simply cannot protect women and children. And in the extreme, our domestic violence death review bodies confirm this in high numbers every year. So other than changes to the new note, what else needs to change, in my opinion? Well, I would argue that the inequality of legal representation in Hague matters is a form of legal systems abuse, which is actually perpetrated by the system itself. So to click on the left behind father here, in Australia, the application is not brought by the father, and this is different from other countries. The application is actually brought by the central authority in the relevant state or territory. So all legal costs are borne by the Australian Commonwealth Government. The father or the left behind parent does not have to satisfy any means, any merit test, or make any financial contribution whatsoever, because it's simply not his application. Contrast the position of the taking mother. She has a really short time in these summary proceedings to sort out representation. Legal aid is rarely granted to abducting parents in Australia. And even if the mother does qualify financially for legal aid, she will routinely be excluded on the basis of merit. And to be honest, at the moment, there's some logic to that exclusion because her case is likely to fail. If a mother is lucky enough to obtain a grant of legal aid or somehow fund a private solicitor, then as Jeff has already mentioned, due to the small numbers of these cases, the lawyer is likely to have never conducted a Hague case, and so the standard of defence work varies enormously. What we do not know is how many women just consent to the child's return to avoid proceedings. And that's in particular rather than acting as a self-represented litigant. Acting as a self-represented litigant is really difficult in all family matters, but it's particularly hard in Hague cases that are heard on the papers alone. So, assuming an order is made for the child to return, upon return, the mother may find that the father has already secured parenting orders while she was busy defending the Hague matter. She might have used up all her funds, while he so far has spent none, because we, like say we, the Australian taxpayer, has paid for his application. What has not yet been properly considered in Australia, and I think it's time that we consider this, is the position of First Nations children in The Hague. The family courts in Australia have made great improvements in relation to the consideration of an Aboriginal and Torres Strait Islander child's right to culture in general parenting matters. The cases are certainly not perfect, but they are much better than they were just 20 years ago. However, none of those improvements have been translated into Hague cases or into amendments to the regulations. And I am not pretending to be an expert on this, but I think we need some expert consideration in relation to this. The quote on the slide is from a very recent case. And I agree with the judge that the mother would be genuinely concerned about the potential for her child as a First Nation Australian to be underappreciated by a court basically in a European jurisdiction. But I also feel that that comment is just such an understatement. The status of First Nations children is underappreciated by Australian courts, who should know better. So how can we expect courts of another country, hundreds of miles away, who know nothing about First Nations Australia, to fully appreciate how a failure to consider a child's right to culture could be seen as a continuation of past policies and practice practices that have already caused extreme harm to generations of First Nations Australian. For First Nations children, the harm to be considered directly relates to being removed from the land, because the connection to land is so crucial. So in conclusion, we've made a good start in Australia, but I think more changes are needed. As I said, I think the wording of the new note to the regulations needs to be improved. I do think the Attorney General through the Family Law Council may be open to doing that, and we're certainly working on that as Hague Mothers. The rectification of the current inequality of legal representation must be looked into. And again, we're hopeful Hague Mothers are actively making representations to the Attorney General around that. I haven't had time to talk about the role of the Australian central authorities, but they need to be reviewed in order to be less partisan, they're just acting for the left behind parent and not considering the case as a whole. And lastly, the position of First Nations children needs to be properly considered with input from First Nations people as the experts on that. So I'm going to leave it there and hand over back to Adrienne. Thank you.
Thank you so much, Miranda. First of all, for the positive developments you've told us about in Australia, and for reminding us about the very, very difficult position of First Nations children under the Hague. We're now going to move on to a video presentation by Ben Keith from New Zealand.
Good morning, afternoon or evening, whatever the timing of the seminar and time zones done to you. My name is Ben Keith. I'm a practitioner in Wellington in New Zealand. And I should begin by saying not only how grateful and a little daunted, for reasons I'll come to, I am to be speaking in such an excellent panel, but also how sorry I am not to be there in person. By the time you watch this, I will be on a plane for a case and having been out of the airport at 5 a.m. I appreciate it's probably 5 a.m. for some of you, so I don't ask you to feel too sorry for me. As well as saying thanks to my fellow panelists and to Ruth and others for a great deal of hard work that's been put into this case and put into the wider initiative, as well as to all of you for turning up. I want to make two very important preliminary points. The first is to emphasize that while I've had the great responsibility and great privilege, great responsibility too, of working with abuse survivors, my perspective is that of a practitioner. I have some insight into their experience, but I cannot share it. The second is that as a practitioner, I'm obliged to say that these are my professional but personal views. They are not advocacy for a past or present client. They are not specific legal advice. That starting point as a practitioner is also really what I've been asked to address today. There are important questions, and others will talk about them, about how the convention can be reformed, whether it can, about how national legislation can be reformed and how to go about that, with the recent Australian example as a very positive development. But my take is very much what can be done at a court level, and particularly what can be done by way of systemic reform to how the Hague Convention is applied within a jurisdiction. My particular focus, my starting point, is a case that a very brave client, LRR, she's anonymized because that's what happens in these proceedings in New Zealand. New Zealand colleague, Daniel Vincent, and I had the privilege to pursue in 2019 to 2020 before the New Zealand Court of Appeal. The reference is in the webinar materials. Now, the LRR case was like many Hague Convention cases in New Zealand. There was very strong evidence of risk to the parent and also to the child. There was a finding in the lower courts that the risk could be addressed through normal police, normal family court interventions, social services and the like. And that was an end to it. And what that really emphasized, and again, I think this is an experience common to other jurisdictions too, is that Hague cases take on a life of their own, that Hague case law takes on a life of their own. And I think there are two things that go on, then at least. One is that judges coming to these cases are told one thing. It's that Hague cases are different and they are summary and they can be pretty grim and they are very different from normal care, custody, protection of children cases. And that line has particular force and it's something to be pushed against. The other is that, in keeping with that, concepts like expeditious determination not only taken to the extreme, but take on really a life of their own, take on a mystique of their own, and end up with extraordinary and basically impossible standards. And what we were facing with the LRR case was that in the previous 10 years, there had, I think, been 3 first instance cases out of more than 100 in New Zealand where the grave risk safeguards had been successfully invoked. There were none in our High Court, which serves as an intermediate court, and the Court of Appeal, the court that we were seeking to go to, hadn't even heard a grave risk case since, I think, 2008, and that was only to turn it down at a leave stage. So we had our work cut out for us. And what we were able to do, both in terms of getting the case before the court, but also getting some real reform, qualified but real, was both at the level of principle and of practice. At the level of principle, and I should begin my comments here by saying that New Zealand, we have some downsides as a small jurisdiction, like that very small number of cases. And the bedding in of what might be called almost myths about the Hague Convention over quite a long period. But we do also have courts that are open to other countries' jurisprudence, to human rights standards and the like, and that's basically what we're able to do. We relied on the ENS cases in the United Kingdom. We relied upon Convention on the Rights of the Child and CEDAW arguments and so forth. We also relied on very good commentary, and we have the benefit of that, including by some of my very distinguished fellow panelists here. We had more difficulty around the guide to good practice, which at that point was in final draft stage. As some of you will know, there is some stuff in the guide that is unremarkable or even useful. There is some other stuff, I think, as a result of an almost lowest common denominator process, that is just wrong or dangerous. And so that is a complication. But the further point, past that level of principle, it's really important, is what we're able to do practically. And this is, I think, the key thing I'd want you to take away today. Again, the judgments that I'm about to talk about are in the materials. What we focused on was what can be done about evidence. Because, and this was a point that came up in the appeal from the New Zealand Central Authority, which was a separate party in our appeal, their line was, well, these cases fail, the reliance on the grave risk safeguards fail, and that was their term, because the fleeing parent can't provide the necessary evidence. And we really took aim at that. The idea that in a child safety context, that in a parent safety context, one should be looking to the fleeing parent and saying it's the burden's on you, and if you can't show the risk, that just seemed at odds with any human rights view, let alone really with the convention as it should be construed. In its place, we aimed for 3 things, as well as pushing that process to one side. And the Court of Appeal, to its credit, said, well, look, burden of proof is a concept that shouldn't be pushed too hard here. First thing we had from the Court of Appeal, and this is in the smaller of the 2 judgments, 2019 LRR, we were able to obtain an order requiring the applicant parent to disclose his criminal history and his child social services history. And that got us access and got the court access to records that we would not otherwise have had. And it moved allegations, what the lower courts had said were allegations of violence, away from being allegations. They were matters of police record and so on. Second thing, the court accepted that there should be active case management. And I think this is a very powerful concept, still being worked through quite how it functions here. But the court said, look, the family court hearing a Hague Convention application should be deciding very early on what's the evidence that's needed and making sure it's got it, mental health evidence, official records, and the like. Third one, and I'll just be brief on this because we're out of time, we said that the central authority had a role to play, and under the convention history, it does. We got nowhere with the Court of Appeal on that, but the full court of the Australian Family Court has, since the judgment in our case, made similar comments. So I think there's real hope there. The net result was that we moved from being a case in which it was all on the fleeing parent to something far more satisfactory. Still not perfect, but a whole lot better. Thanks very much, and my best wishes to you all.
Okay, thank you very much. The really interesting presentation from Ben. I'm now delighted to introduce Nicole, who will talk to us about a seminal and really, really sad case in the US. So over to you, Nicole.
Thank you. Yeah, so I'm going to briefly walk through the life of a case and sort of note some of the critical points along the way where the Hague Convention paradigm in the US really puts survivors of domestic violence at a disadvantage. And at some point I will use a particular case as an example here. I want to start with the very first outreach letter that the US State Department, which is the central authority in the US, sends to, quote, the so-called taking parent after a Hague application has been filed against them. I'm going to just, as a terminology note, in my cases, the taking parent is always a survivor of domestic violence. That's just what my organization does. So I'm going to be using the term survivor instead of taking parent, which I don't always love the term taking parent. So just a note on terminology. So going back to that first official letter that a survivor gets, it's totally unhelpful, right? And it's incredibly skewed toward return being the only real option that they have, without actually taking into account the possibility that the survivor and their child fled to the United States for their safety. The letter that they get doesn't mention any specific defenses. It certainly doesn't mention the Article 13b grave risk defense. It says nothing about domestic violence, the safety of the child, and it doesn't mention that they should consult with a lawyer to understand their rights and possible defenses. And of course, they make no offer to assist in finding counsel because the State Department doesn't do that for respondents in Hague cases. One of our former clients said that the letter made her feel, quote, like a criminal. And another one said that receiving the letter feels, quote, feels like the end of the world. And we all know that there are possible defenses here, but a lot of these survivors, when they first get this letter in this really traumatic state, after they've just fled for their safety, are looking at it and saying, oh my God, you know, nobody's on my side and I'm going to have to return. And that's not always true. So, okay, now we move on to a Hague case has now actually been filed in court. And as Jeff said earlier, it could be state court, it could be federal court. In New York, where I practice, most of the cases tend to be in federal court. So the State Department sends a letter to the presiding judge over that case. Again, the letter is totally one-sided. There's no mention of any specific defenses, domestic violence, the safety of the child. Instead, the letter purports to highlight what the important articles of the convention are. That's what the letter says. These are the important articles. And that is expeditiousness, prompt return of the child, the court's discretion to return the child, even if a defense is established, right? So again, no mention of grave risk, domestic violence, safety, any of that. Okay, so now we move on to a trial before the judge who's just received this one-sided letter from the State Department with this presumption of return. And the fact is, as most people have pointed out here, winning a grave risk defense at trial can be quite difficult. It's narrowly construed by judges in the US. It sounds like judges really everywhere, but in the US, there's a few reasons for this. So one is the misunderstanding of domestic violence and I think more importantly, a misunderstanding of the substantial harm it causes to the caretaking parent and the child, and a misunderstanding of the dynamics of domestic violence, right? The underlying power and control and coercive control nature of domestic violence. And it's getting better. You know, Jeff pointed out, it is getting somewhat better, but I think there's still this, this lack of understanding of the great harm. There's a heavy presumption for return, even where the child's safety is at risk, as evidenced by the two letters I just mentioned. Also, and importantly, it's a high burden at trial to prove grave risk. So under ICARA, which is the Hague implementing legislation in the United States, grave risk must be proved by the higher civil standard of clear and convincing evidence, despite the fact that everything else need only be proved by the lower preponderance of the evidence standard. And now I'll use an actual Hague case that I worked on to illustrate what this can mean in practice. So some of you may be familiar with the Golan case. In that particular case, Ms. Narcisse Golan fled Italy with her young son to seek safety in New York. Now, to try to prove her grave risk defense at trial, that required 9 full days of federal trial, of trial in federal court. There were 7 expert witnesses, 10 fact witnesses, and Ms. Golan spent hours retelling the traumatic domestic violence that she suffered. So you can see that trying to prove grave risk is incredibly burdensome and expensive, right? Because it's basically impossible to, at least in the US, to win a grave risk case without counsel and without the ability to pay expert witnesses, which tend to be very important in grave risk cases. So my organization, Sanctuary for Families, was lucky enough to be able to find Ms. Golan a large, well-resourced law firm in New York to handle her case pro bono and to cover all of the costs. But of course, not all survivors are able to find that type of free assistance, and that puts them at a serious disadvantage. Remember that the State Department does nothing to help survivors find attorneys or understand their rights. And there's no, because the State Department doesn't do that, there's really no centralized system. Sanctuary tries to do the best we can, but we're New York based, right? We're not national. So, so finding free counsel for survivors can be quite difficult. So let's go back to Ms. Golan's case as an example. The trial court, after all these days of trial, the trial court ultimately found that her husband was in fact severely and regularly abusive throughout their relationship, and that he had not demonstrated a capacity to change his bad behavior. And so the court held, by this higher clear and convincing evidence standard, that returning the child to Italy would subject him to exposure to a grave risk of harm. So you'd think that Ms. Golan and her child would be safe for return, right? But the court granted the petition and ordered the child returned anyway. Why? Well, this is the other big problem with the grave risk defense in the US and elsewhere as well, is the use of ameliorative or protective measures. So courts will typically try to bend over backwards to figure out how to send a child back by finding ways to mitigate the grave risk through these ameliorative or protective measures. And I just want to note the word mitigate, right? Not eliminate, which is really unacceptable when we're talking about a child's safety. So at the time of Ms. Golan's case, some, not all, but some jurisdictions in the United States were required to explore a full range of possible ameliorative measures that could justify sending the child back, no matter how dangerous the facts. So it was different in different jurisdictions. Like Jeff said, we have a lot of different judges, a lot of different jurisdictions hearing these cases. Unfortunately, that requisite consideration of all possible ameliorative measures, that was the case law in the Second Circuit, where the Second Circuit in New York, where the Golan case was tried. So the trial judge, even though she found grave risk, created a series of 10 undertakings and conditions that she believed would sufficiently protect the child upon return. Now, these were all very problematic, and I'd love to talk about why they all were awful, but we don't have enough time to get into all the issues there. But in any event, of course, Ms. Golan and her fabulous pro bono team appealed and appealed again. And after a few years, the US Supreme Court ultimately decided to hear her case. They agreed to answer the narrow but important question of whether a court can be required to consider all possible ameliorative measures before deciding that they can deny a petition. So in 2022, the US Supreme Court issued a unanimous decision holding that, and I'll quote exactly what they said, the categorical requirement to consider all ameliorative measures is inconsistent with the text and other express requirements of the Hague Convention. But basically, courts aren't forced to try to find ameliorative measures to justify return of the child. And this now, because it's the US Supreme Court, this now applies to every jurisdiction in the United States. The court also said a couple of other helpful points. The court said that if a lower court does decide to consider whether ameliorative measures are appropriate, it must prioritize the child's physical and psychological safety in that consideration. The court also said that there may be some circumstances that constitute such an obvious grave risk that it's clear ameliorative measures would never work. And the court included domestic violence in the home as one example of a circumstance that may be so obvious that ameliorative measures won't work. So this is really good, great positive case law change for the better for domestic violence survivors. And I think we all owe Ms. Golan a debt of gratitude for how much she fought to get that change. The case has already been cited in a few subsequent cases that have declined to issue a return order. Now, so obviously this is really great positive change, but in my view, it's not enough. It doesn't go far enough. Because it really remains the case that, one, there's this overall presumption of return. Two, grave risk is still very hard to prove and has a high burden. Three, survivors really need to connect with pro bono counsel to help them prove the defense. And there's no easy or centralized way for them to do that. And four, despite this amazing Golan decision, courts are still permitted to consider ameliorative measures in domestic violence cases, and many of them still do. And what I'd really like to see is the case law develop in the US in a way that makes it almost per se unacceptable to consider ameliorative measures if certain grave risk factors are found. And of course, in my view, those factors would be anytime there is the petitioning parent has perpetrated violence against the responding parent or the child. So basically, anytime there's been domestic violence, that should make it per se unacceptable for a court to consider ameliorative measures, and the petition should just be denied and the child kept safely with their caretaking parent in the country that they fled to. So that is my super quick, but I hope not too quick, life cycle of a case. And I'm going to pass the video to someone else, and happy to answer any questions as they come up later.
Thank you so much, Nicole, and particularly for explaining the continuing problem with protective measures that you've encountered. It really does seem one of the key issues we need to grapple with. So thank you so much for that really interesting and enlightening presentation. And now our final speaker, but by no means the least, we are so delighted to have the amazing Sue Duchetti, who's done incredible work over the years in the US on Hague proceedings.
Thank you so much, Dr. Barnett. I want to thank you and your university, and I also want to thank Ruth and Philia for putting this important conversation up and forward. It is such an important topic to be talking about, especially for mothers who are fleeing across international borders. How did this happen to be? I guess I want to talk a little bit about how I got involved in this and how it all started in the US for me working on this particular issue. I am a lawyer by training. I've done a lot of cases working with battered immigrant mothers, going through the US courts and through deportation proceedings. And this difficult case ended up in front of me when Jane Doe walked into my office, where I was the director to the Access to Justice Institute at Seattle's University Law School. And sitting and listening to her, I kept thinking and pinching myself and saying, what is she talking about? What is she talking about? I've never heard of this. What is this? And I realized that if I did not know anything about it, none of the lawyers that I worked with or the judges that I've come in front of understood this case. So I knew that not something had to be done. As soon as Jane Doe walked out of my office, I started to think, okay, what do I need to do? I need to map all of my resources that I have and see how I can use that in order to help her and other mothers like her who I don't even know but need all this help. I realized that I had the university platform, I had the area expertise in domestic violence, I understood about deportation proceedings and the impact that it has on mothers. I knew all the constituents for this, the lawyers, the advocates, the judges. I was working with a librarian who was amazing, who said, I will help you on all of this. I knew I could create a website that I could recruit students because I had them in my classes, and I could leverage Westlaw and LexisNexis. Okay, so now I've looked at all my resources. I know that I can leverage what do I need to do to make a system change. So I put out an order for students to help me. I had over 70 students that volunteered. They helped me create a website. The website was really focused on who would be the people interested in this website, and they would be mothers who needed information. It would be advocates in the US who help mothers, advocates who work in battered women's shelters who would help mothers who came through the doors. And I needed case law summarized to look and see how many of these cases are going to the US courts, what the outcomes have been. And then I need to understand the system. You know, how does this case go through our system? What happens? Where does it go? Who gets it first? And I needed to find alternatives. And then I thought, well, maybe I can change the treaty. And of course, when I went and told my librarian about it, he laughed so loudly. I can still hear that laughter ringing. And then I realized, okay, I've got this, I've got the students, what is my next step? And I realized that everything that I have learned about this and talking to other lawyers, that I now needed to create visibility. I needed local visibility, national visibility, and international visibility on this issue. And I needed to educate funders who actually fund grants in the US on violence against women. And then I knew that I needed to have research on this area. I could not find enough information on this in the US. And so I contacted two very well-known professors in the area of violence against women. One is Dr. Taryn Lindhorst at the University of Washington, and Dr. Jeffrey Edelson, who you've already heard before, who used to be at the University of Minnesota, and asked them that if we could all work together to get funding from the National Institute of Justice and create a study, you know, to look and research about these cases. And of course, what we found is that we got the grant and they helped us with this. And in their study, one of the things, there were several things that were very common to the work that I already do with battered immigrant mothers. One was that these women often suffer through linguistic and cultural isolation, that there is citizenship issues in question, that there is lack of domestic violence and abuse assistance in the countries that they're in, that they do not know how to seek them, and that attorneys and judges in the countries that they need the help in lack the experience in this particular issue. So what did that research achieve? We've got a book, it got an award, and it was amazing because what it did, it provided us systematic information on the cases. It gave me the ability to push for change. It also gave researchers the ability to push for change within the social sciences arena. I got credibility. It gave the issue credibility because funders started to believe in it. We got a Department of Justice grant. People started to listen, and we have an RFP now within the Department of Justice grants. So through the grant that I received, the first thing I thought is, okay, what do I need to do? Who needs to be educated to help these mothers, right? We need lawyers. The mothers need lawyers immediately as soon as this petition is filed, and then they go before the judge. So I need to educate judges, especially because in the US, as Dr. Edelson pointed out, that there are so many judges in the case can land in any one of their plates, that I needed to have a guide for the judges. So that's what I created, a bench guide for judges across the US. And this was created by having in each state 2 judges who chaired the committee that was created. And they are the ones that pulled this whole bench guide together and then disseminated it to other judges in the state. I created a practitioner's guide because every lawyer who comes across any of this case lands on their plate. They are like a deer in the headlight. It's very expensive and their timing is very short, and therefore Therefore, they need all the guidance that they can to prepare this case. And so I created a practitioner's guide for the attorneys that we had a website now through the grant. It was a really good one. We could create model briefs that were then available to lawyers who were working on these cases, and we had a huge body of case law that we pulled together in the US. It also allowed us then to create training for judges, for attorneys, advocates, and expert witnesses. So the lessons that we learned and the lessons that I applied, definitely for anything that we want to do, and for all of you that want to work on this, is that map your resources and leverage them. All of us have it, regardless of what we work on or what we do. That visibility and research is critical for you to push this issue up the table and to make changes and system changes. That we need to identify barriers within the system which you're working through in order to help the case and to make sure that there is justice, and barriers for mothers who are trying to protect the children and themselves at the same time fending off the petition that has now been filed against them. And that it's very, very critical for us to have strategic solutions that are not one-off, but that are actually something that will last and will help women along the way and get them to what they need to get. So my final takeaway on this, because every others have mentioned takeaways, and every one of those are very good. But for me, I think the very important one is that if we could find a way to have the central authorities in each country provide pro bono attorneys for the mothers in all of these cases, especially when domestic violence has been pointed out and is there, that would be the best thing, because these cases are so expensive and take so much time, and that there is not enough time to get due, justice. So this would be the most important thing that I would actually advocate for. Thank you very much. And Adrian, on to you.
Thank you so much, Sudha, for telling us about the amazing work that you've been doing. It just goes to show that with the will and the right people, it's possible.
Yes.
So that's incredibly encouraging for all of us. So thank you so much to all the panelists for your presentations. And I'm now happy to open up the Q&A so that we can put some of your questions to the panelists. I've got a question here for you, Jeff. The question is, do you have any ideas on training the judiciary? SCOTUS has heard several Hague petitions. What is the appeal of the Hague at the Supreme Court? How to advocate on the Hague to the judiciary, including the very arms of the state that deal with the convention?
Well, in the United States, as I said, there's 17,000 judges that potentially can hear a Hague Convention case. And so I guess as a university professor, I'd say training. There's a lot of training that needs to be done, a lot of awareness building and knowledge building among the judiciary. It's often best taught by other judges. So I think finding allies and advocates within the judiciary is really important. And Sudha Shetty might have something to say about that, because her Hague Domestic Violence Project developed state bench guides for judges across many of the large US states, and had judges co-leading state Supreme Court judges and federal judges co-chairing those committees that developed those bench guides, and then distributed it widely to their judges in their state or district, and also included presentations about the bench guides at judicial conferences. So I do think in our context, where we don't have a specific Hague bench, and we have so many judges potentially hearing these cases, that including it in judicial training as much as we can is very important, and developing resources like websites, bench guides, practitioner guides, and the like, which the Hague Domestic Violence Project did, is very important as well. And I think that can be replicated in other countries to varying degrees.
Thank you so much, Jeff. Sudha, I wonder if you'd like to come in on that as well, from all the work you've been doing with the bench guides and the judges.
I mean, all of us that work in social justice know that judges like to hear both sides and they should be listening to both sides, correct? But we also want to educate them. And so one of the things that I realized early on is that it's not enough for me to just talk to judges, but also then to leverage it with training. So at least in the US, we have training bodies that train judges. So reaching out to people who are in charge of the trainings was critical. We have every court has a court administrator who's responsible for the trainings within the state of, in the US, and reaching out to them and asking them if we could be a part of the training when they do the training for judges was very important. And that's how I got started on that. And then I realized that, and it was those judges that told me to create a bench guide for them so that they have that, so that they're not at the last minute when the case appears in front of them, that they're trying to figure out all the information. And so they were the ones that gave me the idea to create a bench guide for them in every state. And so then I decided, yes, that would be a good way. And then I thought, okay, we need to have judges to chair it, because otherwise no judge is going to listen to me and say, when I say, here, take the bench guide, they're not going to take it. But if a judge did that, they would. And so that's how judges I selected in each state, 2 judges who were considered very highly by their peers to chair it. And the committee was made up of people who were advocates, lawyers, mothers, battered mothers, and everybody, so they could hear everybody's voices and the challenges the convention had. And we put the guide together. So it really helped us tremendously in that, because now we are in several circuits and we are in several states as well.
And can I add that judges, while they do want to hear both sides, they do not have to stay neutral on the issue of violence and abuse, and they can be advocates for safe communities. And so the judges that we've seen are leaders for safe communities. That doesn't mean they're biased towards one petitioner or respondent more than the other, but that they are pro-safety and encouraging safe responses in their communities.
Can I also just add, super important, the judges training, and thank you for so much for your work on that. Also, lawyers, more lawyers have to get trained as well, not just in the nuts and bolts of Hague Convention, but also in understanding the dynamics of domestic violence and the harm that it causes. Too many people potential clients have come to me after having been screened at another organization that told them, that DV doesn't sound so bad, or I don't think that's enough for defense, or you don't have any defense, and it's simply not true. So I just think more practitioners really need to be trained in both the Hague and domestic violence.
It was very interesting in the case, Jane Doe, my very first case. Her lawyer told her, when she told the lawyer about all the things that she went through, the lawyer said, oh, but we don't need to worry about that. We're just going to file, without looking at that, because the convention does not ask you to look at domestic violence. And I insisted that she put all of the stuff in that petition so that it was there for us. And that really helped us in the case. And then her lawyer filed a separate dissolution case, again, without putting any of the domestic violence stuff. So that was my first inclination, that here we can have a lawyer who's very good but doesn't understand any of these, and we need to do training. So we actually do a lot of training through the ABA and through the different states in the US.
Yeah, thank you very much. I think that has really made it clear the extent of training that's needed and that can be done, and particularly how to get the training, where it's needed. And through the right channels. I've got a question here for Miranda. So Miranda, do you think things are changing in Australia around the Hague? The questioner says that her daughter and her had to voluntarily return to the UK from Melbourne in 2017. Her barrister looked back over 50 years of Hague hearings, and only one was allowed to stay. That was in the 1980s, and they had a QC. Do you think now there may be things may be fairer, we may be listened to more? Has the mood changed?
Great question. If you'd asked me a year ago, I'd have said absolutely not. Nothing has changed. Indeed, I looked with Annabelle Gray in 2022 at 5 years of cases which involved domestic violence and the grave risk exception, and all of those, an order for return was made at first instance, and in only one was successful in preventing return, and that was on appeal. But that was a really strong case. That was a full court case called Walpole. I'm happy to send anyone the details, in which they didn't use the grave risk exceptions per se. They used the intolerable situation, risk of intolerable situation. The court used it really well, looking at the conditions of return. But I think so together, if the judges actually follow that case and lawyers use that case and use the new regulations, I like to think that the mood has slightly changed, but we haven't had any cases since the relevant cases since the regulations came into force. So we really need to see how the courts interpret those.
Thank you very much, Miranda. And yes, indeed, I suppose this is watch this space and see how things develop. Got a question here from a mother in Brazil, who raises a really, really important issue, which I think perhaps is particularly pertinent for Brazilian mothers and others in the region. Numerous mothers are Hagued and have never been living in the country where they sent with their children. It's very easy for a parent to submit a return. They get a lot of support from the Ministry of Justice, but it's made almost impossible to build a defense. She makes the point in some countries, a Hague hearing is made within 10 days or within 24 hours. And we have been hearing, certainly they're very brief in England and Wales, and we've been hearing about this recently. So I guess the question is about this two problems. One is of children being sent back to countries they hadn't actually even been living in. And the other is the speediness of Hague cases, where clearly welfare and risk can't properly be investigated in such a short time. So perhaps who would like to take that first? It could be something.
I could just
Jeff or Nicole?
Yeah, I could just say something from our research that, you know, I think as a number of you have pointed, the inequality of arms was the term you used. That many times we also found that mothers were given very short notice. The petitioning fathers had time to think about the petition, get pro bono representation through our State Department, and plan the serving of the petition on the mother. The mother, as the respondent, had very little time to respond. We had one case in Minnesota where it was the Friday before Christmas holiday that she was served, and she had, or it was a Thursday, she had to be in court on Friday. So it leaves these mothers with very little time to find representation. As Nicole had pointed out, and me as well, that many lawyers are not familiar with The Hague and haven't had cases in the past. So I do believe that it leaves the respondent parent at a very great disadvantage, and that they don't really have time for due process, that we need to slow many of these situations down, slow them down, and allow time for collecting evidence from another country, translating that evidence, getting translators to help in translating testimony and the like. And those are, you know, this is like a domestic violence case, but with an international context, multiple languages, multiple courts, multiple police jurisdictions, and mothers really do need the time to respond, much greater time than they're often allowed.
Yes, thank you. Thank you very much, Jeff. That certainly is an issue, the speed of proceedings in England and Wales, where there may not even be enough time to you know, get a legal representative, draft statements and so on. Miranda, I wonder if you'd like to explain what the situation is in Australia with respect to the way cases can be moved through so quickly that it doesn't really give the mother the chance to, prepare a case properly, or indeed for the court to properly assess risk.
Yeah, I suppose it's a two-edged sword. I mean, the idea of The Hague was that matters were meant to be done really quickly, and there can be benefits to that in some cases. Many judges, I think, and lawyers are concerned about the new regulations adding time to the cases so that they don't become a best interest test. I actually think that on the whole, cases that look, this is purely anecdotal, cases are taking around 6 weeks in the Australian system, but that may differ from, we have very different registries around Australia that all have very different delays. Yeah, it is very hard for women to obtain representation in the time that they're given. Legal aid is almost always unsuccessful, and then to try and arrange a good private lawyer to get the funding for that or to self-represent in that short time is really difficult.
Yes, that does seem to be quite a common problem across the board. We've had a few questions asking about, do we know about the numbers of Hague cases per year in each of these jurisdictions?
I can talk about Australia. The best way to find out about Australia is from the Attorney General's department's website. However, they seem to have changed their method of counting cases, or not actually recording cases this year as they are wont to do. But certainly in 2021, our numbers are quite small. We have about 100 cases in most years, which are both incoming and outgoing cases that the central authorities deal with. That does look small, but actually when you compare it by population to other countries, Australia actually has a very high relative number of cases. And I don't think that's surprising, given that 49% of Australians were born overseas. We're more likely to have Hague cases, but most of our cases are a third of the cases are with New Zealand and about 20% with the UK, and then other countries below that. Yeah.
Right. And what about the US? I know that the US gets the highest number of Hague cases out of all contracting states. And in fact, the UK gets the second highest number. Do we have statistics? Does anyone?
We do. The Department of State, which is our central authority, the Office of Children's Issues, does issue, as mandated by Congress, an annual census of Hague cases, both incoming to the US and those that are outgoing from the US. Those generally number well over 1,000 in each direction, 1,000 children in each direction each year. The great majority of those come from Mexico and South America, the Latin America, Mexico and south of us. So many of those cases are actually sometimes Mexican citizens who are seeking safety with family who currently lives in the US. So we have a mix of US citizens returning to the US, fleeing with their children, and then Mexican citizens who are mothers who are fleeing with their children to the support of family and social services in the US. The problem with the US State Department statistics is that those really rely on those registered with the central authority. And because many of our cases can, and Nicole talked about most of her cases being in federal court, in our research, about half the cases were heard in state court and half in federal court. And in state court, that sometimes those are not necessarily registered with the central authority. So it's probably an underestimate. But those are available on the Office of Children's Issues, US State Department website, the annual reports.
Okay, thank you very much. That's really helpful. We've got a question here which asks, is it lawful that children can be taken by a bailiff and armed police after a return order? Now, of course, we know in the England and Wales, we have this office called the tipstaff, who are based in the High Court, in the Royal Courts of Justice, and they do have authority with the support of, they can enlist the support of the police to physically, to locate children and physically return them. Nicole, perhaps you can answer this one. What is the situation in the US? Can the police, for example, use force to return children if a return order is made?
I mean, the technical answer is yes. The technical answer is yes. Now, in practice, will they do it? It very much depends on the situation, the age of the child, the willingness of the child. I mean, at the end of the day, they will figure out a way to abide by the order. But it sounds like when you're saying by force, we're sort of talking about like actually ripping. So I guess I don't know exactly what you mean by force. Yes, they can actually physically take a child and you know, take that child away and put it on a plane. They can do that. Has it happened? Of course it's happened. You know, depending on the situation, everybody works together to try to make sure that doesn't happen, and that the separation, the process of separation, is as minimally traumatizing for the child as possible. But yes, it can happen.
I think it depends on where it is. I mean, once I started the project, I heard from a lot of mothers who, for them, they came through the door, broke the door open, and dragged the child out and put them in, you know, in custody or in a foster parent place until the case was heard. So there were several cases where they did come and rip the door open by force and take the children away. Guns, you know, guns blare, you know, pointing, everything, the whole works. They did do that. And I do hope that it has changed since then. Okay,
thank you. We've got time for one last question, and I'm going to use my position to ask it of panelists. One of the issues that we have, certainly in England and Wales, is that if the mother wanted to leave the jurisdiction and not risk getting caught up in Hague Convention cases, she would need to get the permission of the father, or she'd have to apply to court and get the court's permission. And it's become increasingly more difficult to get permission to relocate. So if one asks why does this end up happening, perhaps that needs to get factored in as well, the great difficulty in mothers and children being allowed to relocate, including in circumstances of domestic violence and abuse. What is the situation with being able to relocate? I'll start first with Miranda in Australia.
Well, if there are court orders in place, parenting orders in place, then yes, you have to obtain the consent of the other parent or a court order. You don't have to do that if there are no parenting orders in place at all. And to apply for relocation involves, obviously, assuming that consent is not given, application to the Federal Circuit and Family Court of Australia, and delays are huge. So you would probably, if you go all the way through to a final hearing, you seem to be looking at a 3 years and incredibly expensive process, even if you're successful. It's hard to get a relocation order, but I don't think that's surprising given the huge consequences for the other parents as well, when in terms of the hardest cases, I think judges say. But there's certainly, I think the issue is really the time and expense involved in getting those orders in Australia.
Okay. Thank you so much. Now, I've just been reminded that we only have a few minutes left, so I'm going to short circuit that question from the other panelists, but it's certainly something to think about. And I'm going to ask each of our panelists that if there was one thing you would like changed, what would it be? And I'm going to start first. So the one thing I'd like to see changed in domestic violence and abuse cases is for the hearing on return orders to be suspended so that the welfare hearings can be held with the mother and child remaining in a safe location and held remotely. So that would be my one wish list, I think, top on the bucket list. What about going on to Jeff? What would yours be?
Well, you know, given that for 30 years I've focused on the impact of exposure to domestic violence on children, I would love to see a greater recognition by the Hague Secretariat and by countries around the world that exposure to domestic violence does create a grave risk of a potential grave risk of psychological or physical harm to the child. And coming back to Professor Weiner's article, recent article, that exposure alone is sufficient to prove grave risk. And so I would love to see a greater recognition of these factors.
Thank you. Nicole, what would be top of your wish list?
So for me, I'd like to see it made very clear that ameliorative measures or protective measures are totally inappropriate in cases where there's been a finding of violence by the petitioning parent against either the responding parent or the child. And in cases, in those type of cases, the Hague petition for return should be denied without consideration of any allegedly protective measures. If there has been, if the responding parent has met their high burden of grave risk.
Thank you. Miranda, what would be yours?
Thanks, Adrienne. I completely agree with all the suggestions made so far. And in particular in relation to the virtual hearings, when we actually look at the research that shows that so many of those women actually are eventually successful in their custody proceedings in the country of habitual residence, the damage that's done in between is just enormous. I would like to see a rebuttable presumption of non-return where there are cases of domestic violence, where there's allegations.
Yes, thank you. And Sudha, you've got the last word. What would be top of your wish list?
I mean, I'd say all of the things that every one of you said. And I would actually like the Hague Secretariat to recognize domestic violence openly with all of the countries and have them re-sign the treaty to agree to that piece, and then make sure that every implementing legislation then puts money for pro bono attorneys for the battered mothers who fled for protection.
Absolutely, couldn't agree more with all of your excellent suggestions. So that just leaves time for me to wrap up and give some final thanks once again to Philia for all the support and help for Hague Mothers and for this webinar. Particularly huge thanks to Ruth for all the incredible hard work you've done on Hague Mothers and putting this webinar together. I'd like to thank our co-hosts for Brunel Global Lives Research Centre, all the institutions of our panelists and sponsors in Australia, Durham University and UCL in the UK, University of Berkeley, Nicole, your organisation. Thank you so much for endorsing this Hague Mothers and this webinar. Huge thanks to the Hague team, everyone else who's worked on the webinar. Massive thanks to Sonia and Kim. And a big thank you to our audience, particularly those who have been joining us from at the crack of dawn at one end of the globe and are here at nearly midnight at the other end of the globe. Thank you all for making this webinar a real success. And last but not least, the hugest thanks to our Hague mothers. Every single one of you, we hear your stories, we know what's happened to you. The terrible situation for so many of you who are trapped in countries where you don't have family, you're struggling to find somewhere to live, struggling on little to no money, you know, being subjected to further violence and abuse. And also to those of you who are separated from your children. We mustn't forget that this is another huge violence and injustice that The Hague can cause. We know that there are so many of you whose children are living across the other end of the globe and you can't be there with them. So we're all committed in Hague Mothers to bringing an end to these injustices, to uniting you with your children, and to giving you the freedom and autonomy where you and your children can live without fear and able to live your best lives. So thank you so much, everyone, for coming along to our webinar.